Hi, good afternoon. Today is October 7th, 2025, and it's 3:23 p.m. U.S. Central Time. My name is Rinaldo Javier or J. Aguiar Marcano. So Rinaldo J. Aguiar Marcano. And I'm recording this from my home, located at the 26714 Valleyside Drive, Katy, Texas, 77494. And important to say that I am a political refugee, and my refugee number is M as in Mike, A as in Apple, 39176. And that number was given to me or assigned to me by Canada's Immigration and Refugee Board for claims of persecution against, or persecution made against me by the Venezuelan government for political reasons, right? So yeah, so today this is just a quick session, right? Because I just want to document something that I've observed, right? And I think it's a TTP. TTP stands for tactics, techniques, and procedures. And this is a term that usually people that work in intelligence or in military use to describe these procedures, right, that are used to fight in a war. So this TTP is a TTP used by I coined this satirical term, which is in the glossary of the book. I call them ACME law, right? As in a reference to those cartoons. I don't know if you remember, in the 80s, there was these cartoons. There was a roadrunner and a coyote, right? And the coyote was always trying to kill the roadrunner with elaborate ruses, but that always backfired spectacularly. And he had this catalog, right? The coyote had this catalog where he would, pick things that he would use to kill or harm the coyote, the roadrunner. And I use the term to refer to Morgan Heidner and the Adams law firm and the Roberts, Weinberg, the other law firm that they used to, and all the other law firms that they used to harass every target, right? Because I'm not the only. This is not directed at. I mean, it is directed at me in this case, but this is really a planet scale operation that they've been doing for 30 years or more, right? And there's many people in my situation that they just don't know that this is a systematic attack, right? But there are thousands of other people, right, that they have in the exact same situation as they have me, right? I imagine to different degrees, right, of severity, but what I'm trying to say is that there's multiple people that are being targeted by them in this very same way. So anyhow, I realized this morning, right, because they did it like 3 or 4 times at this point, right, in a very short period of time, and I didn't catch it the first few times, but I was able to see today how it works, right? So I'm going to start by describing the TTP, right? So it's a legal TTP, right? So it's a way. I'm going to start by describing the goal. The goal of this TTP is so they can file. I'm going to describe what they achieve with this, and you will see, so you can see how powerful this is, right? With this, they achieve that they can. Now, this is something I have to do more research on to understand if this really works regardless, right? Or if a skilled attorney, because I'm not an attorney, right? I'm just a proselytic. And so I need to understand if it works because I lack the training, right? The legal training, or if it works well, even against attorneys. I don't know, right? But let me tell you what they achieve with this, at least against unsophisticated respondents like me, right? I mean, proselyticans, or litigants that are represented by attorneys that are part of the network. Because if the attorney that represents the respondent, right, is part of the network, or the other party, it could be also a petition, right? If somebody sues them, they're going to do the same thing, but they're going to be the respondents. But if the attorney that represents the other party is complicit, right, in the network, it's part of the scheme, he will just play dumb, right? And not object to this. And it would work as well, right? But what they accomplish in general with this is that they can file any motion, any document, and any piece of evidence, and successfully getting in without opposition from the other party. The other party cannot oppose if they execute this, right? I mean, think about what I'm saying, right? They have a TTP that allows them to do anything they want, and the other party cannot object. It's constrained from objecting to whatever they do, right? In the legal front. And it does not look like the judge is biased. It looks like it was well done, right? That it was procedurally, that it was a well executed legal move, right? So that's what they accomplished, right? If you think about that statement, it's a tremendously powerful weapon, right? Legally speaking, it's I wouldn't say it's even better than, I mean, I'm trying to translate it to a weapon in the real world, right? In real warfare. I think that would be better than a nuclear weapon, because in a nuclear scenario, the other party may also have nuclear weapons, right? And that could serve as deterrence. But with this thing, there's no way to oppose this, right? And it has to do. Now, I'm going to talk about things that maybe are specific to Texas, but I know that all these legal systems in all the Western countries, at least, have evolved from the same early, legal systems from the Greeks, right? And every country must have some flavor of this rule, right? But I'm going to talk about Texas because this is what I've been doing here, and I know them, the rules here, right? So here in Texas, they have what they call the code and rules of procedures, right? Which is what governs the way that things are done in court. And in one of those rules, I think it's rule 21, but don't quote me on that. I can't recall the number. It says that, if you're going to file a document or, enter something, a notice, a motion, whatever it is, you have to give proper notice to the other party. And that proper notice, it's a number of days, right? And here in Texas, in these circles, they refer to this as the 3 days rule, that you have to give 3 full business days to the other party of notice. Meaning, if you're going to file a document, in court, you have to give the other party that document 3 days before it's going to be used, right? 3 full business days, right? That is the rule of thumb. Now, and that's what they refer to when they say proper notice, right? And the notice has to meet certain requirements, right? It has to be in a way that is traceable, and in Texas, for example, email is acceptable, and you can also file it with the court and use the e-filing system to notify to serve the other party, right? Anyhow, what they do, and this is the TTP. Now I'm going to start getting into what is the actual TTP, right? So. And I don't know, I have to do more research on this, I have to confess, right? To see if there is another rule that, sorry, this warning again. To see if there is another rule that prevents this loophole, right? I mean, this Texas has been around for centuries, right? Like the legal system should have something in place to prevent this, right? So maybe it's just that I'm ignorant and I don't know how to, what is the kill switch to kill this, right? But this is the way they work, right? So I'm gonna, I don't know, maybe the best way to do this, right? I'm going to open a calendar so you see what I mean. Okay. Okay, I think I'm gonna do this. Okay. Okay. Let me share my screen. Okay. So that's a calendar, right? Just an empty calendar. And I picked that week, the week of the 20, just as an example, okay? So this will be the week of the 20, the week of the 20 to the 24 of October 2025. So imagine, right, that the hearing, I'm just going to make a fictitious hearing in here. I'm going to say it's going to be on Friday from 10 to 12, from 9 to 11, I don't know, a.m., right? So this will be the hearing, right? Just hypothetically, right? So if you're going to use a document, imagine that hearing is, let's make this example interesting, right? So imagine that hearing is to formalize in writing the orders that the judge gave, a judge, right? Any judge. So, and hypothetically, that the opposing, the attorney that is going to do that draft is Morgan Heibner, okay? So to be able to use that document in that hearing, the attorney must give notice at least 3 days, full days, right? So the attorney has to send that document at the latest on Monday afternoon before 5 p.m., right? Okay, because that way, right, the other party has the 21st, the 22nd, and the 23rd, 3 full days of notice, and the document could be used in the hearing. But this has a flaw. I mean, and this is what I don't know if there's a kill switch for this, but think about it this way, right? Imagine, right, at the limit of this limitation, if Morgan Heibner says the document on Monday 5 p.m., even, right, if the other party gets the document and takes them 1 minute, imagine, right, that it takes them 1 minute to read it, only 1 minute, and another minute to generate an objection. They have an objection. In that minute, they were able to read the 40 pages document full of boilerplate language that Morgan Heibner injected in there to confuse them, right? But somehow, in 1 minute, they're able to read the document and understand it. And then it takes them 1 minute to generate the objection. So 2 minutes in total, right? So if they do this, if the other party is so fast and they can do this in 2 minutes, they could send their objections at 5:02 p.m., right? But by that point, it's too late because the objection, when Morgan Heibner receives it at 5:02, is already past the deadline for the 3 days notice. So when she gets to the hearing on Friday, what she will do, she will tell the judge, and she has done this 3 times on the record already with me, right? She will tell the judge, I did not get proper notice for this. I object to this objection, to his objection, right? Like I move the court to strike his objections because he did not give me proper notice. So and this was possible because she sent her document, the one that the other party is objecting to begin with, she sent it at the limit of what the Rule 21 says. So the 3 days at the limit, right? And this is in the best case, right? What she would do in reality, she would send the document the night before the hearing. And she has done this multiple times, and I've complained, I filed motions for sanctions. Like, this is documented in that case. It's like, at this point, it's like beating a dead horse. Anybody can go into that case and look it up, and you will see what I mean. But because I went to the appellate court, right, and with all these documented, and this is called judicial ambush, right? This is a term the lawyers use to describe this technique of sending documents the night before a hearing, so the other party is overwhelmed and doesn't have the time to prepare a proper response or even prepare for the hearing. And this is a violation of due process. Basic violation, right? I mean, a profound violation that every lawyer knows. When I say basic, I don't mean that it's light. I mean that everybody knows that this is a violation. So Morgan Heibner have done this repeatedly. I have objected repeatedly. I have submitted motions for sanctions, and nothing has happened. The judge hasn't ruled on those motions, right? At this point, there's like 4 motions for sanction pending for ruling by the judge. And Morgan Heibner keeps doing it, right? So I went to the appellate court, and I raised that issue, right, to prove bias in the court, or to show bias in the court, in the state level, in the district court. So because I did that, right? So what she did today, which is what let me see it, is that this morning she sent, because I filed a document with the appellate court, basically destroying her two drafts and calling out what she's been doing, right? So now this morning she sends me at 9:18 a.m. a slightly modified version of the same fraudulent orders, but she sent them at 9:18. So she sent them on it. So today is a Tuesday, right? So she sent them. So to put it here, so you can see it graphically, right? So she sent it here at 9:18 a.m. Say Morgan. So Morgan Heibner sends at 9:18 a.m. on the Tuesday, right? So this was this week, not on the week of 21st, but this is just a hypothetical week, but just to give you the same timeline, right? On a hypothetical week. So at 9:18, Morgan Heibner sends her third fraudulent draft, right? But you see, this is what made it obvious to me, because I started counting, and well, she was short 20 minutes, right? Like it wasn't 3 full days. It was 2 days in terms of business days, right? It was 2 business days and 7 business hours of notice that she gave me. She didn't give me the full 3 business days, and that makes the notice invalid, right? And I realized that even, right, if I reply immediately, I am already late. She will say on Friday that I did not give her proper notice, although she did not give me proper notice, but because the court might be biased, it's going to go her way, right? So with this, right, I mean, when they operate in this way, they're guaranteed to be able to get any document they want without objections in the record, any motions, anything. And the other party doesn't even have an opportunity to reply, right? Because when they reply, they will say, oh, you did not give me proper notice. And this is yet another example, one of hundreds at this point, of them applying the law in a way that hurts the adversary, but when it comes to them, they disregard the same law. They ignore it, right? The law doesn't exist for them. But, you know, in this case, right, because she already has done it three times before, and she did it today, because now she cannot send the document the night before, because I already went to the appellate court. And I don't know, like, this is a mystery to me. I don't know what level of access that appellate court would have over the records of the lower court. I don't know the answer to that, meaning, like, I don't know, right? The appellate court is a review court. I imagine, right? If you're going to set up, if you're the government, right, and you're going to set up this system, this legal system, and you're going to set up one court, one higher court to review the work of the lower court, if I was the government, I would give access to the higher court to the systems of the lower court, so they can go and dig into the documents and see what happened without having to file documents and, you know, to streamline their capabilities, right? So I don't know what is their powers in terms of digging into what they've done in the lower court. But because I see the change in behavior, right? Before, she would file documents 12 hours before the hearing, or 15 hours, like at 6:01 p.m. the previous afternoon, right? Before the hearing. But now she's doing it 2 days and 7 hours, business hours, right? 2 business days and 7 business hours before the hearing. So she's trying to do it at the limit, right? And that let me see, oh, this is what they're doing. But like, and this is what I need to research on my side, is because my system doesn't have this capability of finding second order effects yet, right? I mean, for the application of the procedural rules. I don't know if there might be, I don't know, yet another procedural rule that says, well, you know, the rule 21 or whatever number it is, right? The rule that governs the notice period applies in this way if it's not a hearing, because if it's a hearing, it should be double the time. Why? Well, because you also have to give the other party enough buffer so they can reply and give you proper notice too, right? You have to assume that they may object to what you're doing, right? So this I imagine, must be encoded into the procedural rules. It's probably that I don't know how to, well, what it is and how to trigger it, right? Because that's the other problem with the system, is that when you go to court, enabled to do certain things, you have to, it's like they have like magic words. It's the best way I can describe it, right? Like there's certain languages that you have to invoke or say, otherwise what you're saying is not valid, right? Even if you're right, even if what the other person is doing is an abomination, if you don't say the magic words, the magic tree doesn't grow, so to speak. Which is what I was referring to the other day of the justice system not being accessible to the people, really. It's a system that it's under the control of a professional circle, and if you don't go through that, circle of professionals, you cannot get access to the thing, which I think is unfair, right, by definition, because we all live in this society and we should all have access to the justice system. It's a basic, I don't know if it's a human right, but if it's not, it should be, right? Like everybody should have access to justice, right? Anyhow, but I finally understood the TTP, right? So the TTP is filing the documents in the worst case, in the worst case for them, exactly at the deadline of the 3 days. So the other party effectively, in reality, doesn't have a chance to reply. And if they do reply, they can object saying they didn't give me proper notice, right? The other party didn't give me proper notice. And the judge will say, you're right, right? As it happened on the September 11th hearing, and this is on the record, right? The judge lectured me, and this is on the record, about, it's a long story, right? So I gave notice to the judge, not to Morgan Heibner, to the judge. My notice was addressed to the judge saying that I'm withdrawing my consent to all the agreements of the September 8th hearing because they were made under coercion. They had me under the threat of a psychiatric evaluation. So I was afraid that if I didn't agree to everything they said, they could use that to justify a psychiatric evaluation. That's the very definition of coercion, right? It's like pointing a gun to somebody to the head and asking them to negotiate. So I sent my notice of withdrawal of consent to the judge, not to Morgan Heibner, right? And I sent that the very same day after those agreements happened. And those agreements were on September 8th. So I sent that notice on September 9th, right? But they had set the other hearing for September 11th. So you see, that is the same TTP. Well, it's not the same TTP because that was a notice. It was an unilateral notice to the judge. I don't have to give, I don't know, like for my notice to be valid to the judge, how can Morgan Heibner say that I did not give her notice? The notice is to the judge, not to Morgan Heibner. So I have to clarify this. But the one who could say that did not get enough notice would be the judge, not Morgan Heibner, right? Because the notice was addressed to the judge, not to Morgan Heibner. But anyhow, right? That's a good example, right? So the first hearing was on the 8th, right? Imagine that. And this was a week, so, well, you can see it in the numbers of the day, right? So 8, right, was the hearing. I withdraw my consent on the 9th, and the follow-up hearing to get the verdict rendered verbally was on the 11th, leaving only the 9th, 8th, 9th, leaving only the 10th, September 10th in the middle. So what I'm trying to say is that these two hearings, right, the hearing of the 8th and the hearing of the 11th, were scheduled so close together that if I had any objections to what happened on the 8th, Morgan Heibner automatically had the nuclear weapon of saying, you're not giving me the 3 days notice. But of course, I could not give her the 3 days notice because the two hearings were scheduled with only 1 day or 2 days in between, right? So by definition, by design, it was impossible for me to ever give her any proper notice on anything about the hearing that happened on the 8th. And this is the TTP in action. And this is important because this means that, I've noticed, and I complained about this to the appellate court, that there's unequal access to the calendar of the judge. When I try to schedule an emergency hearing to rescue my son, the scheduler gives me a hearing 30 days out, a month out. But Morgan Heibner is able to schedule things 2 days, right, with 2 days notice. As an example, on September 8th, she was in front of me when she scheduled the hearing for September 11th. And I thought the level of access was the weapon, but it's not the weapon, it's the TTP. Because by doing that, because she has the ability to schedule things close together, with that, she disables any possibility of objection because she has the magic card of saying you did not give me the proper notice. So that's why the access to scheduling things with short notice is important, because that's the TTP. And that means that the scheduler has to be in it, right? And that's why the scheduler gives Morgan Heibner hearings with 2 days notice for non-emergency things like attorney's fees, right? But does not give me the same priority in the calendar, even if I'm asking for an emergency motion because I believe my son is kidnapped by legal means. So the nuclear weapon really is the scheduler, right? That's why I was saying today in YouTube that, you know, it's simple yet incredibly powerful, right? Because it disables the possibility of the other party ever objecting to anything, right? They have it's a legal setup in which the objections don't exist for the other party. That's what really is, right? And this is possible because of the scheduler, the way the scheduler is working with them, right? Incredibly powerful, simple, and deniable, right? Unless you have the geo index, which I have, right? The scheduler has to have a house, and the scheduler, you know, it's the same thing, right? Like, how can you hide a house, right? So that's the TTP that I wanted to go over. And also, because of this, ACME law concept, I registered the domain Roadrunner law, right? Maybe I'm going to, create a product after the legal vaccine, right, that I've developed. Because that's the funny part, right? So she sends me this document, right, at 9:18 a.m. this morning, basically disabling any possibility of objection, because then she will say that I did not give her notice. But because I'm doing this with computers, I'm not doing this, I'm not reading the document. I'm having my software do this work for me. So I was able to file a very powerful response to her draft in about, I think it took me 60 minutes, 65 minutes end to end. So in a little bit over an hour, I was able to file with the court a super powerful response, and with like 12 different arguments, right? Objections. So I filed a formal objection to that fraudulent third draft that she sent me, attaching the draft to the document so it's in the record, right, of what she's doing. And it took me only 65 minutes. And I did not have to really read the document, right? Like the computers, I have 500 cores working on this problem. They did it for me, right? And I think it's a powerful demonstration of power because, I'm telling her, even if you give me, 60 minutes notice, I will still be able to reply. And she cannot object based on the notice thing because I replied 1 hour after she sent me the document. I mean, what is she going to say? That I have to reply immediately? I have to, in a second, read the document and produce a response and file it? No, right? And her draft was sent to me without proper notice to begin with. And that is the first argument in that list of objections. So I think she has to drop that, right? She has to drop that technique. She has to find another way. That's not going to work. And the more she does it, is more evidence for the appellate court or the Supreme Court if I eventually have to take it there. Okay. So yes, so I'm gonna make I'm gonna work on the branding of that company, the Roadrunner law. To turn it into a product, probably open source. Like, my goal is not to make money to that, but it's to open access to the system that right now, at least in the areas controlled by this network, a regular person doesn't have access to, because they don't know the magic words to get a motion or to get an exhibit into the record or things like that. And well, this to close this session, I'm going to talk about something funny, right? It's this little number over here, and this is really funny, but I mean, it's funny to me. But when I look at this, it reminds me, how far I've come in these 2 years. I'll tell you the story behind this, right? So when Sarah Pretty, right, the neighbor next door that Diosdado Cabello moved next door to me in 2021 or 20, the husband is Michael Pretty, who works at Citgo, the Venezuelan control company. There was an incident in which they were harassing me, and she inserted a dog, like they dug a hole under my fence and inserted a dog in my backyard to then knock on my door, asking me to then if they could come into my house to retrieve the dog, right? Knowing that I know that they are working for Diosdado Cabello, right? Well, I didn't know Diosdado Cabello at the time. I thought it was WebMD, right? But I know they were spies, right? Let's call them unregistered foreign agents, right? To be technically appropriate. So, when they did that, and this is where this comes into play, my response, this was only 2 years ago, right? My response was, I went on Amazon, which is one of the most funny things, right, of this story. I went on Amazon and I bought this. And this is a security camera that is fake. This is a fake security camera. It doesn't have really any electronics inside. It's just a fake device that looks like a security camera. And the idea is you install it, and it's to serve as a deterrent to people that may want to break into your property, right? Because they will think that it's a real security camera. And it cost like $5. And I bought this. I bought like half a dozen of these, right? And I put them around the fence. Because I saw the prices of the other security cameras. And as I said before, I'm very conscious about how I spend money. I didn't want to spend $2,000 in security cameras, right? So I bought these fake cameras for $5 each. And I put them around the fence. And this is funny to me because imagine, right? Like, with everything that I've said in these videos, right? Put that in perspective. 2 years ago, I do this, and they must have been laughing, right? They would have been like, "Oh, so cute," like he's adorable, right? With the level of surveillance, the house is wired, the infiltrations, the friends that are working for them, law enforcement, everything, right? Amazon, right? The supply chain, and I both, all of them knew that the cameras were fake, of course, right? Of course, it did not deter them. If anything, they probably laughed about me buying fake security cameras. But it's one of those things, right? I look at this and I think, well, on one side, I think how naive I was. But on the other side, I think, how far I've come, right? Like, for example, today, I was able to, rebuild Morgan Heitner ambush in 60 minutes, right? Using technology. And that's the takeaway of this session, is that it is possible, right, that they've been controlling the world for decades using law, right? I think that is the pillar of the base of control at the end. But the way to defeat that is, ironically, through the use of technology, right? It's the only way, because they cannot fight with a distributed system of computers finding legal arguments, right? They can't fight with that because they don't have that capability, and they're humans, right? It takes them longer, as I said before, to produce the motions and the fraudulent temporary orders and drafts and all that. It takes them longer than it takes the computers to find the weaknesses, right? So the solution to the legal vector of attack is technology, right? And that's ironic because at the end, this network is a technology company, right? At the end, right? Well, I'm going to close this session for now, and I'm going to make another one later. Thank you so much. Bye-bye.